Hello, friends. How are you? Thank you for joining me today for our discussion, attorney chat. And I want to talk to you guys again about the Keeping Families Together program that the Biden administration through USCIS implemented on August 19th. Now, if you want to learn more in detail about what this particular parole in place program is about, feel free to check out my channel and my other videos where I talk about this. I also have some blogs about it where I go over what the requirements are. I'm not going to do that in this video. Here, I want to just go over some frequently asked questions that I get regarding this program. And the reason why I want to do that is because a lot of people have been asking me questions. Now, as you are aware, and if you aren't aware, on August 26th, a U.S. District Court basically administratively stayed this program and stopped USCIS from making any further approvals for any parole in place applications that they receive. Now, originally, the stay was for 14 days and it has been extended. However, while they're not allowed to make any approvals on any applications that they receive, they are continuing to accept applications for the Parole in Place program. So if you haven't applied yet for this program, you can still submit an application along with all your supporting evidence. And you should, in the event that they are going to be making further approvals, you want to actually take advantage of this opportunity. Now, let's say they are no longer able to grant parole in place. What happens to your application fee? Unfortunately, USCIS is not going to refund you your application fee. So apply at your own risk. Understand that you are taking this opportunity and it's a possibility that you will not be refunded in the event that they are no longer able to approve these applications or if you get denied. But I want to just go over some frequently asked questions that I've been getting. The great thing is USCIS has a really comprehensive, excuse me, frequently asked questions tab on their website that answers so many of your questions. So I am not going to be able to answer all of the questions that they have on their website, but we can go through a few of them. And I encourage you to go to their website and review these questions. I think that they did a good job in answering and breaking down different questions that people may have concerning this program. If your case is nuanced and you're concerned about facts concerning your particular case, I really encourage you to speak to an experienced immigration attorney. One, you want to make sure that you qualify for this program. Two, there might be circumstances in your case where your attorney might say, hey, this is probably not the best opportunity for you to, work on, or you can apply for this program, but you have to also do some other things because of certain facts in your case. So either way, I encourage you to go to the USCIS.gov website and take a look at this frequently asked questions about the keeping families together. Okay. All right. So let's start with the general questions that they have on here, right? The first question is, what is keeping families together? Now, keeping families together, it's a process that allows certain non-citizen spouses and children of U.S. citizens to apply for parole in place to enable them to become a lawful permanent resident without having to be separated from their families by leaving the U.S. Now, this program is specifically for those who are married to a U.S. citizen and if they are the stepchild to a US citizen, right? And the purpose of this is because in certain circumstances, whether, for example, if someone came into the country without inspection, like crossing the border, and they don't have proof of lawful entry into the US, even if they're married to a US citizen, or even if they're the stepchild of a US citizen, they are not able to, under the immigration law, apply for adjustment of status. Now, adjustment of status allows a spouse of a U.S. citizen to apply for the green card and subsequently receive their green card in the US. Now, those who came in without lawful entry do not qualify for this process. And what happens is they will have to apply for a waiver for their unlawful presence, and they have to go through a different process called consular processing. And that may require them, and that does require them actually, to go back to their home country and get the green card there and enter with the immigrant visa. Now, for a lot of people, that is really scary. It's very scary to take that risk to leave. For some people, they're afraid that, if they go, and this has happened to some people, where they are stuck outside of the country and they have to sit out for a number of years, right? They have a 10-year bar, right, before they can come back into the country. So the Biden administration, they created this program because they want to keep families together. And that's the name of the parole program, keeping families together. Many of these people have been married for many years. There's been some data around some of the average amount of people that are going to be benefiting from this program have been here for 10 plus years. So these are not for new folks that are just coming in. This program is for people who have been here for at least 10 years, came in unlawfully. They don't have a visa. They didn't have a visa when they entered, and they're married to a US citizen, and they can prove and provide evidence that they have been living here continuously during that time, right? So you have to provide evidence of all the things that I mentioned. So the next question, which form should I file to apply for the Keeping Families Together? Can I file online? So right now they're only accepting online applications. There is no paper application. The form is called I-131F, application for parole in place for certain non-citizen spouses and stepchildren of US citizens. And you can only apply for this online. So if you try to submit a paper form or application or submit your evidence via the mail, it will be rejected. Don't waste your time. You can only do this online, so you have to create an online account in order to do this. You can have someone assist you. Attorneys are helping people. If you have a family member who can help you, if you're not too tech savvy, fine. But it has to be done online. Now, what is the fee required to file a request for this application? The current fee is a flat fee of $580, and there's no fee waivers for this particular program. Okay. Someone told me if I pay them a fee, they can expedite my form and or guarantee that I'll be approved. Is it true? Now the answer is absolutely no. Okay. So you can have an attorney or an accredited representative work with you and prepare your request. I'm an attorney. I do this for my clients all the time. However, we will never guarantee you a faster processing time on any application, because it's really unpredictable. It's really going to depend on USCIS's current processing time. It's going to depend on the facts of your case. So if anyone's telling you that they can guarantee you that they're going to move this along faster and help you get approved, please, please, please walk away. That is a red flag. Okay? All right. So if my Keeping Families Together request is granted, how long will my parole period last? So USCIS says in general, if you're granted parole as a non-citizen spouse or non-citizen stepchild of a US citizen under this process, your parole period will be valid as of the date USCIS approves your form, and it will expire 3 years from that date, right? So remember, parole terminates automatically if you depart the US. So just because you received parole does not mean that you should leave. It's not an advanced parole where you're asking for permission to come back into the country. So if you leave and exit the country, just know that you have now terminated this parole in place. And also DHS, USCIS can decide to terminate your parole at any time, right? They have that discretion to do so. For example, if you commit a crime, they can decide that they're going to terminate this parole in place for you, okay? So many people are taking advantage of this parole so that they can stay here. And what they want to do, and they should do, if they qualify, is apply. Once it's granted, is apply for adjustment of status. Okay. All right, we talked about the criteria. I'll go over it really quickly. You have to be present in the United States without admission. So if you came in with a visa, you don't qualify for this. Have been continuously physically present in the US at least June 17th, um, 2014. So the last 10 years as of when they made this announcement. Through the filing date, you have to have a legally valid marriage to a US citizen on or before June 17th. You have to have no disqualifying criminal history or otherwise not deemed to be a threat to public safety or national security. And they're going to have you submit biometrics. You're going to go through a background check to make sure that you don't pose a threat to national security or public safety. Okay. And again, it's very comprehensive answers here in their FAQ section. I encourage you to take a look at it. So I'm not going to go over every single question that they have on here. Okay, let's see. I have already departed the United States from an immigrant visa interview appointment at a U.S. embassy or consulate abroad. Can I make a request for keeping families together? Again, so this process is only available to non citizens who are present in the U.S. without admission or parole. So, non citizens who already departed the United States, they may be eligible for consular processing. So, this is only for those people that are currently in the United States. Okay. Let's move to the next section. This question asks, how do I make the request under keeping families together? Again, I mentioned this earlier. You have to do this online, right? And if you go through this document, they give you examples of different evidence and supporting documents that you can submit to meet the qualifications: proof of your identity, proof of your legally valid marriage, or if you're a stepchild, proof that your parents were married, right? Proof of your spouse's status, because remember, you have to be the spouse of a US citizen. So if you're married to a green card holder, unfortunately, this does not apply to you. You also want to provide proof of continuous physical presence in the US during the required period of time. And there are many different ways to do that. You can provide tax returns, rent receipts, utility bills, bank statements, insurance policies, hospital or medical records. If you went to school, school records. You can have attestations from your religious entities showing that you have been an active member at your church. You can also provide any birth certificates of children that you had here during the past 10 years, and money orders or receipts, that you um, had, here in the US. There's a bunch of different documents. If you're working with an attorney, your attorney will help you with coming up with what are good supporting documents that will help prove continuous presence. Okay, proof of your qualifying relationship to your US citizen step parent, that's important. And then you want to also demonstrate that you merit a favorable exercise of discretion, because this is a discretionary program. So you want to show that, hey, I am a good person, right? I've been here. I haven't committed any crimes. I have strong ties to the community, no criminal history. I paid my taxes. Anything that's going to show that you would warrant a favorable exercise of discretion will be very helpful, and you should provide that evidence as well. Okay. So now the next question is there a deadline after which USCIS will no longer accept requests for keeping families together? And there is no current deadline for this process. However, because of the injunction and possible future injunctions and the outcome of this current stay, right? We don't know what that will look like. I really think it's important, if you're considering applying for this program, that you shouldn't waste time and do it now, because it's very possible, we've seen this happen before, where programs have been shut down and people didn't take advantage of applying and missed out on that opportunity. So there's no current deadline for this process, but that doesn't mean that there won't be one in the future. So you want to take advantage of applying for this program as soon as you're able to. Okay, this next question talks about showing continuous physical presence. We went over that. We talked about favorable discretion. So this question asks, will USCIS verify documents or statements I provide to support my request? And it says USCIS has the authority to verify documents, facts, and statements provided to support immigration requests, including requests under this process. We may contact relatives, educational institutions, other government agencies, other entities you verify to verify information. In addition, USCIS will conduct background and security checks. If USCIS determines you have made a material misrepresentation or engaged in fraud as part of your request will be denied and you may be ineligible or inadmissible for other immigration benefits in the future. You may also be subject to criminal prosecution. So essentially, you want to provide legitimate documents for this request and any immigration benefit that you're applying for. You never want to lie or make a misrepresentation that will make you inadmissible. And then you have a whole nother issue you have to deal with where you have to ask for a waiver of the inadmissibility based on misrepresentation. So you always want to be honest with USCIS, telling the truth, providing actual legitimate documents. You don't want to commit any fraud when you're applying for this benefit or any benefit. Okay, so am I required to demonstrate that I am not inadmissible in order to qualify for this process? And they said no, right? Parole is neither an admission to the United States nor a determination of admissibility. As a result, requesters do not need to demonstrate that they are not inadmissible as part of this process. However, USCIS may consider facts and circumstances that may give rise to one's inadmissibility in making a case-by-case discretionary parole determination. And requesters who subsequently apply for adjustment of status will be evaluated for admissibility at that stage. So no, you don't have to prove that you're admissible, right? That is not your role. Your role is to just provide evidence to show that you qualify for this program. However, that determination will be made when you're applying for adjustment of status. And when you do your adjustment of status application, there's a whole bunch of questions that's on there that is asked of you, the applicant, to determine whether or not you're inadmissible or not. Okay? And this is the same question and same answer when it comes to the public charge ground of inadmissibility. Let's see. Okay, this is another really good one. Someone has asked me this. If USCIS denies my request, will I be placed in removal proceedings? Okay, so they said if we deny your request under this process, we generally will not issue a notice to appear, an NCA. So that's when they refer your case to ICE. They're saying they generally will not do that, right? Solely based on the fact that they denied you for your case. So I know a lot of people are worried about that, right? Like, if I get denied, am I going to now be, facing deportation? So they say they generally don't do that. USCIS maintains discretion to issue an NTA or refer the case to ICE for possible enforcement action consistent with governing policies and practices. So they do have discretion to do so, right? But it doesn't mean that they will. If they find out that maybe you are a threat to national security, it's possible that they could initiate a notice to appear in immigration court. But the likelihood of them doing it, if you have no criminal background issues, is probably going to be low. Okay, here they have a bunch of questions about marriage. So, what is considered a legally valid marriage? I encourage you. Let's review it. USCIS will generally recognize a marriage as valid for the purposes of keeping families together if it's legally valid in the place where the marriage was celebrated. The parties to the marriage were legally free to marry. So, if you were married before and your divorce wasn't clear and you married again, you weren't free to marry. So you might want to look and speak to an attorney about that. And the marriage is not contrary to the public policy of the US, right? They will consider it valid. The place of celebration is generally where the ceremony took place or where the officiant of the ceremony was located and where the marriage certificate was issued. Even if a marriage is valid in the place of celebration, there are circumstances where USCIS may not recognize a marriage relationship as valid for the purposes of this process, consistent with existing case law and policies for family based immigrant visa petitions and other benefits. So let's see what examples they provide us. Examples of the types of marital relationships that USCIS generally will not recognize for the purpose of this process include, but are not limited to, civil unions, domestic partnerships, or other relationships that do not confer the same legal rights and responsibilities to the parties as a marriage recognized by civil authority. Marriages that are contrary to public policy in the United States, marriages where one or both parties to the marriage are not legally free to marry or have not given consent to marriage. Okay, I think that's pretty self explanatory there. Are common law marriages considered legally valid marriages for the purposes of keeping families together? USCIS recognizes common law marriages in adjudicating immigration benefits in certain circumstances and will similarly recognize them for purposes of keeping families together if the parties live in a jurisdiction that recognizes common law. So that's going to determine where you live. The parties meet the qualifications for common law marriage for that jurisdiction. The marriage is valid and recognized by the jurisdiction in which the marriage was established, and the marriage was established on or before June 17, 2024. So that date is very important, right? Because you have to be able to show that you were married, right? On or before this particular date. Fortunately, if you got married the day after, you're not going to qualify for this program, okay? So if my U.S. citizen spouse has died, am I still eligible for keeping families together? So what does USCIS say? If your U.S. citizen spouse has died and you have not remarried, you may still be eligible for keeping families together process. However, to be eligible for immigrant visa petition approval and eligible to apply to adjust status as a widow of a U.S. citizen, you must meet other eligibility requirements. And for that, you can look at another form that they have on here, a very comprehensive FAQ regarding that for the I-485 adjustment of status. Now, there's a bunch of questions here. Really, really encourage you to look at it. There are questions for stepchildren and how to prove eligibility as a stepchild. There's also questions regarding your continuous physical presence in the US. Let's look at this question really quickly. Do brief departures from the United States interrupt the continuous physical presence thresholds criterion? Also, if I'm granted parole, will a brief casual and innocent absence from the United States affect my eligibility for adjustment of status? Let's see what they have to say here. Okay, no, a brief casual and innocent absence from the United States will not interrupt your continuous physical presence in the United States during the required period for the purpose of keeping families together. For the purpose of this process, a brief, casual, or innocent absence means an absence from the United States that took place prior to June 17, 2024. Okay? And one, the absence was short and reasonably calculated to accomplish the purpose of the absence. The absence was not because of departure under an order of exclusion, deportation, or removal. The absence was not because of an order of voluntary departure or an administrative grant of voluntary departure before you were placed in exclusion, deportation, or removal proceedings. The purpose of the absence and your actions while outside the United States were not contrary to law, and you are not a threat to border security. Okay, so this is really important to know. So if you had a really brief absence from the United States, you should be fine as long as it doesn't fall under one of these exceptions. Okay, here you can talk about, look at if you're in removal proceedings. A lot of people are curious to know, can they still apply for this program? And the answer is yes. I encourage you to read this. Yes, if you are otherwise eligible for parole in place under this process, including that you are present in the United States without admission or parole, USCIS will consider your request if you are currently in removal proceedings before an immigration judge. This is really good news, right? So you can go ahead and apply even if you are in removal. So there's a bunch of questions here about removal proceedings. I'm not going to go through each one, but I encourage you again to take a look at this FAQ, okay? Okay, let's just look at this question really quickly. What impact does having a criminal conviction have on eligibility for this process? So all felony offenses will be disqualifying under this process. Okay. Convictions for, so if you have a felony, I would talk to an attorney, don't apply, because you could be creating bigger problem for yourself if you put yourself on notice. Talk to an attorney. But just know that all felony offenses will be disqualifying under this process. Convictions for the following offenses are also disqualifying regardless of whether the conviction was a felony or misdemeanor. DHS reserves its discretion to determine that other offenses are disqualifying. So even if you have a misdemeanor, right? Um, any criminal conviction that you have, don't apply for this program without an attorney. I really encourage you to work with an attorney before you apply so that they can evaluate your case to determine whether or not you're a good fit. So we have murder, torture, abuse, offenses involving firearms, explosive material, engaging in a whole bunch of stuff, including trafficking, aggravated assault. There's a whole list of different crimes here that will automatically, I don't want to talk about all of them here right now on this platform, but you can read and you can see for yourself, right? If you do have a criminal conviction, please work with an attorney. Okay. Let's see. We have a bunch of questions. There are questions about background checks. They're going to do a background check on you. Absolutely. Okay. Okay, this is a good question. Can I appeal USCIS's denial of my request under Keeping Families Together? Unfortunately, no, you cannot appeal the decision if we deny your parole in place request. However, you can file a new request with the new additional evidence demonstrating your eligibility with accompanying $580 filing fee. So you can apply, you can appeal, but you will be paying again for the application. Okay, so let's see. I-601A provisional unlawful presence waivers. I have a pending form I-601A application for provisional unlawful presence waiver. Can I still make a request under Keeping Families Together? And the answer is yes. You may make a request for this process while you have a pending form I-601A. If you're granted parole in place under this process, you may be eligible to apply for adjustment of status to that of a lawful permanent resident by filing the form I-45, okay? And you can do this in the US without first seeking the provisional waiver, okay? So this pretty much helps a lot of people who came in without an inspection and they're applying for the provisional waiver. The form I-131F with this program really helps those people. It just helps them to be able to apply for adjustment of status, like I talked about earlier, without having to leave. Okay, that's a really, really good thing for so many people. All right, there's so many questions here about it, and I'm going to go through the employment authorization questions and then wrap it up. Okay, so if my request for Keeping Families Together is granted, will I be eligible to request employment authorization? Yes. If USCIS approves your request for Keeping Families Together, right, you can apply for employment authorization. That's the EAD under the form I-765. Under eligibility category C11, you can only apply for employment authorization after your Keeping Families Together request is approved. Okay, so that's great news. So while you're after you receive the approval, you can apply for a work permit. You can work, and you'll have that, and you'll be able to apply for adjustment of status. So you'll have a work permit. Hopefully, it gets approved quickly while you're waiting for your adjustment of status to be approved. So this is really, really great news. Again, there are so many questions on here. I cannot cover every single question in the video, but I encourage you guys to go to the www.uscis.gov/keeping families together/FAQ, and you can look at all of these questions. If your question is not on here, you can go ahead and write me. You can leave a comment under this video. You can call me directly. We can set up a consultation. Maybe your case is, again, very nuanced, very special, and you have a specific question regarding your case. I will be happy to talk to you about it, and we can discuss your options in a consultation to see whether or not this program is a good fit or whether or not there's another benefit out there that you may qualify. If you have any questions about, again, this program, you can go ahead and give me a call. I'm happy to talk to you. And until next time, I will see you all in the next video. Take care.